If you are a home buyer, home seller, or property agent, then you would have come across booking fees, which is usually paid by the purchaser to reserve the property before they formally enter into a sales and purchase agreement, or the SPA. Well, then you might be surprised by the recent federal court case that says this collection of booking fees under housing development, although it's a common practice, it is actually prohibited, illegal, and whoever tries to do so or assists in doing so commits a criminal offense. In this video, me and my senior Mr. Marcus will talk about the things you should know about the federal court case of PJD Regency against Housing Tribunal. The reason why the court held that collection of booking fees is illegal, prohibited, is because under the Housing Development Regulations 1989, Regulation 11 sub 2 says, no person, including parties acting as stakeholders, shall collect any payment by whatever name called, except as prescribed by the contract of sale. That contract of sale refers to the statutory SPA prescribed under the HDR, such as Schedule G, Schedule H, which does not provide for the collection of booking fees. Therefore, like what has been highlighted by the Chief Justice, under Regulation 13 of this HDR, whoever collects booking fees or whatever name is called for this payment infringes the law and commits a criminal offense. The rationale behind this prohibition is understandable, which is to protect purchasers from unscrupulous housing developer who, having collected booking fees, take advantage by either delaying the construction of the project or formalization of the SPA. But what is more important as between the purchaser and developer is, what if there is a collection of booking fees? Then how should the liquidated ascertained damages or LAD for late delivery be calculated? This is the key issue of the case. In the statutory SPA, there is a clause that provides that the developer shall hand over the property within a specified period of time. Schedule G, which is mostly for landed properties, says 24 months, and Schedule H, which is for strata properties, says 36 months, failing which the developer has to compensate the purchaser in the form of LAD for each day of delay. So where the developer has been late in delivering vacant possession, meaning the developer has missed the time frame within which it must hand over the property to you, then when does this LAD start to run? Is it the date of collecting booking fees or the date as stated in the SPA?
So what the case have decided is that if you collect booking fees, the calculation of LAD will begin from the date you collect the booking fees, meaning if you're late for no matter how many days, so that portion of LAD will be calculated from the date you collect the booking fees instead from the date of the SPA.
The position taken by the federal court is that although this collection of booking fees is illegal, but it should not be void or invalid, because that would be more detrimental to the purchaser. Instead, the moment when any payment is made in relation to the purchase of property, it must mean that a contract of sale has been formed.
The moment you want to collect money, you have to make sure you are ready to sign. At the end of the day, the court basically put their foot down and say that the HDA is a social piece of legislation, so they should be interpreted in the favor of the purchasers. So the developers cannot collect booking fees knowingly when they can't, and tell the court you should start calculating from the SPA. So the court took pro-purchaser. They want to protect purchasers from unscrupulous developers. If you collect booking fees, you start the calculation LADs from the booking fee.
And you might wonder, does this law apply to all kinds of properties transaction?
This only applies to properties purchased under the Housing Developers Act, meaning residential properties. For commercial properties, it falls back to the normal contractual law. Okay, whatever you and I agree, that will be on a different set of law, different case. There's a very recent federal court case also for LAD for commercial contract. It doesn't apply to subsale because that would be on a contractual basis already.
Of course, there are other important rulings having been made in this landmark case, such as that LAD shall be calculated based on the purchase price as stated in the SPA and not the amount after deduction of rebates given by developer, and that common facilities is only deemed completed upon issuance of CCC and not CPC. However, it remains this issue of collecting booking fees. that has sparked the most debate and mixed feelings between purchasers and developer. Because this practice of collecting booking fees may not necessarily be bad for purchaser. It is, I believe, designed for the mutual benefit of both parties, so that purchaser can reserve property and under circumstances it can be refunded, like where your loan is not approved.
This is of course personal opinion. We are bound by it nevertheless, but there is actually a reason why people collect booking fee or sign a letter offer. Then you collect. They do this, they get the letter offer, they run to a bank. So they run to a bank, they want to see whether you can actually afford the property, whether your credit score actually can clear to get a financing to purchase this property before they tie themselves up under the SPA, where you straight away have to pay the developers the 10%. So in terms of the law, in terms of practical practice, I think sooner or later there needs to be something that to meet in the middle. So the purchaser also don't face the risk of, I sign the SPA, I have to pay the 10% within how many days, and I can't afford because I didn't get a loan. So when I want to get a loan, I don't meet the timeline to pay the first 10%. Purchaser's default. Taking into consideration, if that happens, what would be the legal position be? Bearing in mind, HDA is to protect the purchasers, but now the purchasers are the one default now.
Anyway, this case has surely put to rest the conflicting decision on calculation of LAD. So in a way, it has brought certainty, especially to the purchaser who is trying to claim for LAD. That being said, the impact of this case on developer still remains to be seen, especially during this difficult time of COVID-19 pandemic. Thank you for watching. I hope you have benefited from this video. If you'd like to listen to the full interview of Marcus by myself, please click on the podcast link below, where I will try to put on some interview or discussion between me and other lawyers on legal issues which I think the public should be concerned about. In the next video, we will talk about the problem being faced by tenant in MCO. If you're interested, click like, share, subscribe. I see you next video.